Hi, this is Brian Parker from Law and Lawyering Unplugged. That's a plug for MTV, I guess. Today we're going to look at analyzing a case and figuring out how to win for the client. A client contacts you. What do you do? First of all, two things. This is given under the auspices of the education, information, and maybe entertainment value. You be you, use your state rules the way you use them. I'm here to kind of untwist the top, and then you can do everything else in your state. I'm offering attorneys and real people a look at how I analyze a case so that you can use that in your everyday, either helping yourself or helping your clients. First, you have to listen to your client. One mouth, two ears. I can't tell you how much that rule has benefited me financially and referral-wise because I listened. And in the end, I helped somebody get out of a sticky situation, as I've been in my past, so I know what to listen for. And if you don't, listen more. That's the best way to catch up the learning curve, is if you listen, then apply that to either what you know, what you find from my website. My website at collectionstopper.com podcast plus is chock full of everything you need to make me unemployed, for a client to help themselves, or an attorney to create a practice. If you use my techniques, you'll have $50,000 to $100,000 extra in your pocket. Listen to the client, and what prism that we want to go through is the how, what, why, where, and when. At the end, at the end of this video, under the category of when, I'm going to give you a bonus tip that'll incorporate everything I'm about to tell you, and it's a bonus tip from my ex-wife. Who is contacting your client and why? Is it through a lawsuit or through a letter? If it's a letter, it's usually a 1692G or Dunning letter. Immediately have the client send you the letter, email it or fax or whatever, and then call them back so you can see what and why and how and when inside the letter. There are responses necessary within 30 days-ish. The rules have sort of changed. There's sort of a safe harbor provision that the Federal Consumer Board has created for all debt collectors to send to clients. It's actually longer than the legally required 30-day rule, but go to my debt collection and dispute video for exact way to either you to respond or have your client respond. The work you do with the 1692G letter or first contact can overshadow your response to the eventual lawsuit. 50% of the times when I have my client send a debt collection validation letter, the creditor or collection company goes away. They may appear in another format, but it alleviates the strain if your client needs to get other stuff taken care of before they go forward and having to deal with this. If it is something on the credit report is the first contact. Why do I use the first contact? The actual law under the FDCPA 1692G, and then we're going to put it on the screen, Shazam, 1692G. It's all about the initial contact. So if you did not receive a letter, client, and something popped up on your credit, look for the words date opened. That is when the 5 days starts, even when it's an FCRA touch on your credit report. Because the FDCPA 1692G says 5 days from the initial contact. It's on your credit report not because they just like to keep you involved. It's a collection attempt. So anytime a collection attempt is initiated, be it through your credit report or a letter, that 5 days starts, meaning you must receive all of your validation rights. And you normally do in a letter. If you don't, now you got something. But if it shows up on your credit report, there's no validation warning there, but that is a collection attempt. every case I've read said placing something in an account that's usually called collection account right on your credit report is a collection attempt. So your next who is it a debtor or a buyer? A debt collector or creditor or debt buyer. These notes I'm sort of reading from, I'll go off the rails. The show notes, I write these up for every video for someone to go review on my website, collectionstopper.com, podcast plus. I will create a section that just says how to analyze and win a case, which will have the following: my show notes, an actual lawsuit that I've analyzed. You can see my chickens scratch. Sorry, chickens, because I'm sure you use great penmanship. And then you can see how I answered the lawsuit, how I applied an affidavit. So keep that in mind as we go through this video. A good place to start is my debt collection and dispute video, or how to defend a debt collection lawsuit. They're out there. I've got like 22 of them. They're all very helpful. Find out the date that the client had a debt against them first opened on the credit report, or there was a letter. Or thirdly, if the first contact came in the form of a collection lawsuit. A lot of debt collectors, debt buyers, they say to heck with the validation letter, and that's because it causes so many headaches on their end if the client responds with a validation letter. It just slows all the stuff down. The law firm's not making money by sending you letters. Think about that. They're making a ton of money, putting you on your heels to pay them money if they file a lawsuit. They try not to engage you in letters. There are firms that, as a matter of course, will send the letter because of the contract they have with the client. Hey, if you send out 100 letters, we'll give you 5% of everything that comes back. There's all that going on in the background. It's never about the truth or who owes what. It's all about the debt collector and how it makes a living. Generally, my clients are coming to me from phone, referral. I have a free evaluation form set up on my website, but most clients jump over that and go straight to my email contact and get a hold of me. Best thing they can do is provide me with the lawsuit. 95% of my cases, 99 actually, are some format of a debt collection defense. So have your client send them the complaint they're facing. Most important, find out when they were served and how were they served. Were they served in personally? Well, they've got 20 to 21 days to answer. Were they served in the mail? That's a different amount of time in some states. Also, you got to think about when you call them back, how you analyze this thing. I need you to think about the shadow, the looming, growing shadow of securitization. Ignore it at your own peril. Ignore it at your client's peril. Ignore it at your pocket's peril. You will receive more money quicker if you have a securitization prism to look at these things through. Go to my video, go online. I've got one, what is securitizations? Actually, I have two. One is shorter than the other because the other one bored the crap out of me. Hopefully it doesn't. You fast forward it to the good parts. But the what, after the who's coming after your client, the what is it a lawsuit? Any future claim, counterclaim, or defense for your client rests upon your first review. My review, usually I'll take the lawsuit. It's an actual lawsuit for my client, and there's only 6 counts. And I've circled, and you'll see this online. Who wants to look at me? In fact, boom, put it on the screen, and you'll see they're claiming to be the owner of a note they were assigned without naming who assigned them the note. That's significant. This originally was a Genesis Credit Union debt, and then another company got a hold of it, and supposedly, now check this out. Look at the lawsuit. It'll be supported, and I say supported laughingly. In this case, they've got the word assignment, and Genesis has served it and assigned it to Reliamax Surety Company. You're never going to hear from them again in this lawsuit. So obviously, in my case, Security Credit Services is suing my client. So Reliamax has to pass it on to Security Credit for Security Credit to have standing. So that was in 2018. My client's debt was passed on to somebody else. Reliamax. And then out of the blue, Security Credit Services in their next assignment creates what's called an Affidavit of Debt and Verified Bill of Particulars. This drives me nuts, and it should you too. It's a person, I gotta put this nicely, without a law degree or any information, thinking if they add the words legally sounding. And they do this all the time in titles and sale documents. They just, flowery words that don't mean anything. They're weasel words, but they sound legal. In this case, 1220, my client was sued in February of 2023. They're claiming my client under oath is a defendant and they are plaintiffs. They've created a legal looking thing. This is not a true statement. Why? What's the biggest problem is if you go online, go to Podcast Plus. Remember Reliamax? They're not mentioned in this as sending the debt to the plaintiff, who is Security Credit Services. This goes on every day. It is huge. It's a broken chain of title. The weird thing is, Security Credit Services supporting its own documents and lawsuit does not mention Reliamax, and they wrote this. So that is a what and a why? Why would they not put the company who they're going to claim gave them the debt after the debt was given to them by Genesis? Why wouldn't they put it in the thing that they created? Because they have greater plans of claiming it came from somewhere else if the S hits the fan. It maybe is coming from a trust and they're aware of the securitization of the debt and don't want to hold themselves to Reliamax, if indeed it can be proven by someone like me or someone like you that it's been securitized. So they just say they got it, but they don't say who gave it to them. That's not an affidavit. You got to have two parties to a, if you will, a contract. And again, it's been signed the 20th of December of 2022, and the name of the person signing it you cannot read. If they're an authorized agent, authorized for whom? Meaning, if Citibank, and this happened in the foreclosure crisis, has somebody be an attorney in fact, there has to be a document saying, yep, you can sign for us. They just say they're an authorized agent. Who they are, we do not know. Who authorized them, we do not know. Again, in my other videos, I've talked about bricks. These are many bricks. And again, under oath that your client is a defendant, false. Under oath that they're plaintiffs. Lawsuit wasn't filed until the next year. So it's a self-serving, actually the worst thing they could do, because they broke their own chain of title. And this is something I preach constantly. You'll see this on Podcast Plus. Look for their own paperwork. They have to give you a modicum of something, because 9 out of 10 times the debt is going to get defaulted, so the judge has got to see something. But they don't give you everything, and that's where you get them right in their grill with their own paperwork. So place the lawsuit in front of you. This is simple. Before you send it to the client, before you call the client back, and just put F, meaning false, 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 and of course the assignment, which has no proof and no mention of Reliamax, DF, definitely false. There's nothing true. In fact, what's normally true is where the client lives. Client doesn't even live there, so they defaulted him and then garnished $9,000 from his debt. And that's the first time, his bank, that's the first time he heard about this. The proof of service that their own processor, and again, this is your own work, their own paperwork, says he does not live here. Lady that answered the door said she lives there and she doesn't know who that guy is, and yet they went ahead and told the court, yep, we served him and here's our garnishment proof. There was none, so I used that against them and I got this judgment overturned like that. Garnishment, back, gone, money, all in the same week. Not that I'm any great shakes, I just read. Yeah, I can read. And you too can read your way to great success for your clients. So place that lawsuit in front of you. It's a 6-paragraph schlocky garbage, which is normally the case with collection lawsuits because they're pumping out thousands of these and they don't have time to be precise. You do. That's the beauty of you. Don't answer these things in 5 minutes or less. Answer yes, no, deny, who cares, blah, blah. I want you to intricately detail, because you're going to face a motion for a summary disposition on your counterclaim. They're going to claim, we don't know what he's talking about. So you have to use great detail for the court. The court will love you. I always have judges saying, thank you, Parker. We don't want to default these people. They're our constituents. I know Bob, and now I got to default him. So be a good analyzer for your client's case. And as I always say in my deposition videos, the longer you take, the shorter the thing will go. So if you take an hour to perfect your defense, detailing, and you'll see my answers on, I'm not going to do an answer video here. What I do want to do is talk about the counter affidavit. So after you've done the discussion with your client, gone over the T's and the F's, find out their location. For example, in this case, a real case, client didn't even live where they sued him. So he's got an uphill battle there. I got everything wiped out. Motion to set aside the default. Now we're going after him. And I just wrote him. It took me hours. I hate myself for doing that. But once I'm in it and I get so mad, I want to do the best job I can. So now we've got an answer and we counterclaimed based upon the counter affidavit. When you go through the client's complaint, remember, it's all about the assignments, baby. Is there an assignment? And here we saw there were two going this direction. There's no chain of title. Their own paperwork, which I wrote again and again in the answer. Also, is there a contract? No contract. Does the client recognize the law firm or this company that says they own the debt? No. That's in your account affidavit. There is, quote unquote, an affidavit attached to the lawsuit. So under the state, probably under your state, under account stated statute, the burden of proof, which is everything, drops on the poor client, especially if they don't know what the heck's going on. Now they're defending a lawsuit. They didn't file. So when you do a counter affidavit, the way I've shown you on my website, I might do a video just on counter affidavits, but there's so much there you don't need it yet. The burden of proof goes back, the counterclaim puts them on their heels. I don't charge my clients but a small fee if they've got $10,000 or less claimed against them. Greater than that, I go for a little larger fee because they do humanly put up a battle if it's above $10,000. It's good for the IRS, good for the sensitivity of someone going, I'm not eliminating $10,000 or more debt, but they will. I've done $31,000 in a middling case like that. And you will too, using the techniques I'm showing you. But the defense starts with your affidavit creation. So I create it in my head as I'm listening, and you should use 2 ears, 1 mouth, ask the right questions, and incorporate what you hear into your affidavit, and then you send it to the client for their signature. That is the basis of your answer, your affirmative defenses, and your counterclaim. It rides with you, man, and it puts them on their heels. You're looking for defenses such as statute of limitations. What's the statute of limitations in your state? ID theft. Did someone take your ID? A little tip, 40 to 50% of my ID clients, relative took their ID and information and used it. I represent husbands and wives, and I have to keep saying to the other side, I don't know anything about this because my client did not initiate the debt, even though he knows his wife did it. We find out, or the wife knows the husband did it. It's quite uncomfortable, and a lot of times the spouse will know what the other one did, but say, do not say anything to the other side. They still are protecting the spouse. And I've kind of been in one of those relationships where it's right in front of you, the person's bad for you, and you still stay with them in spite of I don't think anybody's stolen my ID. I'm a sucker, what can I tell you? The assignments are everything, baby. If there's no assignments, as in this case, no standing. 30% of the cases that you will see are 30% of the cases are bad venue. Because they're bad debt, they're old debt, old information, they'll sue you in the wrong venue. And now you have $1,000 for your client and attorney fees and costs. And that's an analysis of this real case. I'm going to follow up this case where I've done a counterclaim and an answer. I'm going to file a federal lawsuit against the law firm. They need to be smacked around a couple of times. So after you've placed the lawsuit in front of you, you've listened to the client, you've looked at the problems with their lawsuit, you've got the counter affidavit. You may want to look at some of my videos, how to defend against a debt collection video. I'm working with a new camera. I hope I'm not too close today. You have to think about securitization. I'm sorry, even the word is horrible. It's like medical malpractice. What the heck is that? So it is the prism you must now look from this day forward. If you're a guy or gal that's been doing this 20 years, securitization is the key. I also think it'll be the end of debt collection as we know it today. I'm seeing movement now in responses to my cases. So you should look for people talking about AI platforms or funding sources. Those are just code words for secure trust. And they try to manipulate or negotiate away from secure trust with courts by claiming, oh, it's just a funding source. It is, by the way, but it's still owned by somebody else. And therefore you got an assignment to the company that eventually they claim sent it to your plaintiff. That's why this company has not named who gave them the debt, because they're not sure either. And you'll see that on the video. Let's put that aside, the Security Credit Services affidavit of debt and verified bill of particulars on. And look for Reliamex, and you will not see it. I'm going to give you something of a small piece of advice that my ex-wife gave me. It's a very smart person. She was elected in a very Republican district, first Democrat in over 200 years since the Constitution. Why? Because she decided and took it on herself to just go to every door in her potential constituency, knock on the door and say, what problems do you have and how can I help? And then listened, kept her mouth closed and then listened. That extra 5 minutes that she listens and then compliments. A lot of times she liked looking at the doors that her district had. A lot of her district was rich, so that people had these huge doors, or they had nice gardens, or they had a nice bunch of chairs. She remembered every single thing just by asking a question and taking 5 minutes. And when she got quite famous, we'd walk in a restaurant or something and people go, oh, and she'd go, oh, Debbie with the nice flowers. I don't know how she knew that, but one of the ways she knew that, and people loved her for that because she's connecting. So my point is, be a connector against the collector. The collector doesn't even know it's client most of the time because I depose their client, and a lot of times the clients are like, my firm did what? And then you get them battling. But be a connector to your clients. It can only help you and your clients. But after I'm done with the client, I take 5 minutes to ask them about their home life, their businesses, what's going on with their kids. And it is a 5 minutes of your time to humanize you, to humanize their situation. If you haven't gone through it, like I have, I know every single thing that the clients have gone through because I've gone through it. I know the ostrich in the head where you just put it away and now you're calling me 19 days out of the 20 the 19th day, you need to, I file so many answers at the last minute. But get to know the person. When you talk to them down the road, your clients, how's Johnny doing? How's your husband's new job? That is a connection that will bring rewards in client-attorney relationships, future cases, referrals, all because you took 5 minutes. Like my ex-wife said, take 5 minutes to figure out what clients want to do. So my ex-wife won in a Republican district as a Democrat for the first time since the U.S. Constitution was signed because she just listened for 5 minutes. And no one had ever done that in her district because the Republicans, not taking one side or the other, thought the seat was a gimme. The next time she ran, they invented a person that looked like her, sounded like her, same religion, etc. But that person still didn't go and do the nitty-gritty of just sitting in front of people and going, how can I help you? What is going on with you? And clients are connected the same way if you just take 5 minutes. So that's when I will admire you if you just one mouth, two ears. And you will hear, by the way, then I'll end this, the throwaway stuff where a person just says, oh, I wish my mother hadn't done that before she died. I say, what did she do? Oh, she signed up for a bunch of debt. Now, we just found out a great defense. ID theft, it's not my debt. And sometimes the throwaway occurs in the 5-minute discussion. So be good for your client, for yourself, your practice, your defense of their case by that 5-minute connection. Be a connector to beat the collector. I always come up with these silly sentences, but that's be a connector to beat the collector. You know your client, you know your case. All right. By the way, I've made great friendships of former clients that we check in with each other all the time. So that's your when you have found everything. To avoid the default, make sure you squeeze out all the information you can for that all-important affidavit. So this is how to pick and analyze a case and figure out how to win for the client. I will create a section on Podcast Plus just for this, just for show notes, just for this complaint we looked at, and I'll throw in an answer there from this lawsuit with that counter affidavit. So listen, look at my stuff, and then see how I flowered the affidavit in the same way I'm talking about. You're on the side of good here. And if someone has taken the time to say BS or lies against your client, you have every right to go swinging, man, and get in their grill in a way that makes them think twice about doing this again. Because that's, sometimes I think, if I smack this guy in the nose every once in a while, he's not going to do that stuff. Now, I'm just a pebble on a beach or a cell and a fingernail, but I can make a difference. To be very honest with you, most debt collectors that know me hate me. They hate the fact that I'm in the way of something so easy, something so quickly accumulated, money from your client's bank account. Even in this case where I pulled them right back from the abyss and stopped the judgment and stopped the $9,000 garnishment just by using their own stuff. I can't say this enough. In my debt collection lawsuit videos, securitization videos, it's right online that everything is securitized, and I always attach the creditor's financial reports for the year your card was created, the debt was created, and put it right on Exhibit 2, Exhibit 3. You'll see all that on my securitization section of Podcast Plus. So this stuff is rich, rewarding, and everything you need is listening to the client, having them tell you about how they perceive the lawsuit and its lack of issues, which goes into the counter affidavit. The counter affidavit is the gas in this engine. The counter affidavit is the blood in the body of your defense. It's so important. This whole thing is about creating that counter affidavit, regardless of who's suing your client. But remember the who, what, why are they writing a phony affidavit? And when? When were you served? When was the default? You can go to my default judgment and garnishment video and you'll see similar instructions from me, but after the fact, if you want, if you're faced with that, if your clients or yourself are faced with that. But focus on the debt collection lawsuit defense. And this is how to analyze getting a case, and the debt collection lawsuit video is what to do with it. But this is a pretty good rundown of both videos. I hope it's helpful. Subscribe. Help yourself. You can have all my free stuff. It's on my videos. Free! You can contact me for 15 minutes and I will talk to you about your idea or case. Go ahead. I may or may not eventually have classes down the road. I see YouTube companies do that. But I just want to practice. If I'm bad at it, I won't do it. But maybe together we'll come up with some great ideas. So interact with me. You can catch me all the time. So I am ending the how to analyze a case and figure out how to win for the client video. I hope it's helpful. Like, subscribe, etc. I thank you very much.